Welcome, everybody. Thank you for joining us this evening. A big thanks to Crystal Logan and the Aspen Community Programs team for organizing this event, and Jenna Moe and the Society of Fellows for their involvement in making these kinds of events possible. Also, please join me in thanking Bob and Soledad Hurst, who have endowed this lecture series. The lights are bright, so I can't quite see which of our trustees may be in the audience, except I know that Ann McNulty and Bonnie McCloskey are here because I've already seen them. Our chair, Margot Pritzker, may be here or is on the way. We have a great board, and one of the fun reasons why I'm mentioning this is because Judge Michael Luttig is the newest member of our Board of Trustees. So while all of you are going to call him Michael or Judge, I call him Boss Luttig. Thank you. Thank you so much. So let me say one other thing, too, which is that this is a busy week. We have 3 Republican governors tomorrow who we'll be hosting an interview with, and I think it is New Hampshire, Mississippi, and Oklahoma. They're still sorting it out, but that will be a big opportunity. And then on Wednesday, we have the journalist Carlos Lozada being interviewed by Wendell Wilkie, who's here in the back. So please come out to those events. We will give you 1 college credit from the Aspen Institute if you attend all 3 events. There is so much going on here all summer long, and it's just a blast to be able to have these moments together, learn together, meet the speakers and the moderators and ask questions, and you're in for a treat today. Everybody is. Well, we're here to talk about something that's important and timely. It is American democracy, where we stand and what could be at stake. How should we think about the issues at play right now? It's my honor to introduce you to our panelists. So I'll start with J. Michael Luttig, who is on the U.S. Fourth Circuit Court of Appeals, where he served from 1991 to 2006. He is now counselor and special advisor to the Coca-Cola Company, in addition to being a trustee of the Aspen Institute, as a trustee of the National Constitution Center, and of other important nonprofits. He's held all sorts of roles in the private sector, including executive vice president and general counsel at Boeing, and they probably could have really used you the last couple of years. And as senior advisor to the Boeing CEO. His judicial appointment was from President George Herbert Walker Bush. Before that, he was Assistant Attorney General at the U.S. Department of Justice, Assistant Counsel to President Ronald Reagan. Last November, he received the Aspen Institute's highest award that we give, our Public Service Award, at a ceremony that we held in New York in November. Judge Luttig, thank you for being here. And he'll be interviewed by Judge Barbara McQuaid, who's a judge, sorry. I'm just,
promoted me, I'll take it.
At least those who know you give you that status, I'm sure. She's professor of the practice at Michigan Law, with expertise in criminal law, national security, and civil rights. She was the first female U.S. attorney for the Eastern District of Michigan, serving from 2010 to 2017, has also been a vice chair of the Attorney General's Advisory Committee. Barbara is a legal analyst for NBC News and MSNBC, has contributed to many publications. She previously served as Assistant U.S. Attorney and Deputy Chief of the National Security Unit in Detroit and practiced law with a private firm. Professor McQuaid, thank you for being here. Have a great evening, everybody.
Thank you, Dan. Dan, thanks very much for that introduction. I am so thrilled to be here. What a wonderful place, a place where ideas can be cultivated in the most spectacular setting on earth. And so I'm really honored to be here. And it's not often you get to interview one of your heroes, but Judge Luttig really is one of my heroes. I think it was Arnold Palmer who once said he had called a penalty on himself during the U.S. Open that cost him the tournament, in 1960 or something. And he said, you shouldn't get extra points just for doing the right thing. Judge J. Michael Luttig did the right thing, but he did it during a time when it was certain to bring on him all kinds of disparagement, disinformation, outrage, and hostility from people who were aligned with his former party, and yet he was willing to do it anyway. And so in the case of J. Michael Luttig, you should get extra credit for doing the right thing. Well, I want to start, Judge, sort of the beginning of the whole January 6th saga, if we can. As we learned as the committee hearings before the House played out, Vice President Pence actually reached out to get your counsel, through his counsel, to find out if this idea that President Trump was floating, that the vice president could simply choose not to certify the outcome of the election, was permitted under the Constitution. And they reached out to you, and you gave some really critical advice. Can you share with us how that conversation went down and how you made that decision? I'm just so curious about that.
Thanks, Barbara. And thank you, the Aspen Institute. Thank you, Dan Porterfield. And thank you, Margot Pritzker, Chairman of the Board. It's an honor, it's a real honor for me to be here tonight at the Aspen Institute. And it's a special honor to have been added to the Institute's Board of Trustees very recently. This is a special night for me in many ways, not least of which is that my wife of 43 years is with me tonight, Elizabeth. Unfortunately, for the past 2 years, we've not been comfortable traveling together, much less having her in the audience wherever I was appearing. Such is America today. So it all began on January 6, 2021, one of the most fateful days in American history. We all know what happened that day. The day before, January 5th, Elizabeth and I were at our home in Vail, and we were having dinner. And I got a call from one of my best friends in life, Richard Cullen, who was the outside counsel to the Vice President of the United States, Mike Pence, at that time. Richard and I spoke every day for the previous year or two, and so it was no big deal that he was calling. And he said, he always calls me Judge for whatever reason, and I said, he says, Judge, what are you doing? I said, we're just having dinner. He said, let me just ask you a quick question. Do you know John Eastman? And I said, yes. He was a former clerk of mine 20 years ago or so. And I said, why are you asking? And he said, you don't know, do you? And I said, no. And he said, well, John was in the Oval Office today advising the president and the vice president that the vice president effectively could overturn the election to one day thence, okay? I'm sorry, that was the night of the 4th, 2 days thence. And I said, gosh, Richard, I didn't know that. And I said, well, you can tell the vice president that I said he has no authority whatsoever under the Constitution of the United States and the laws of the United States to do anything but accept and count the electoral votes that have been transmitted to the Congress of the United States by the 50 states of the United States of America. And Richard said, he knows that that's your view. And I said, well, then there's nothing else I can do. I said, I'll be glad to help in any way possible. And I hung up, and Elizabeth, who had been hearing one half of the conversation, said, my God, what's going on? And I said, I guess the vice president is considering overturning the election. And she said, do you know what that would mean for America? And I said, yes, I do. And she said, as any good wife would, she said, you have to stop this. She said, you can stop this and you must. And I said, hon, I haven't been in Washington, D.C. for 30 years. I couldn't find my way there. I said, I'm not part of the government. I haven't been for many years, and no one could care less what I say. And she pled with me the rest of the night, and we went to bed with her pleading for me to do something, and my pleading back to her that there was just nothing that I could do. The next morning, I get up early around 4:30, and I was having coffee, and Richard Cullen calls me back. And, Judge, what are you doing? I said, I'm having breakfast. And he said, we have to do something immediately. And I was aware in that instance of the gravity of the moment. I knew what he was talking about generally, but of course had no earthly idea what he was specifically talking about. And I said, okay, what do you want? And he said, you have to get your voice out to the country immediately. And I said, Richard, I said, I have no way to do that. And no one would care if I were able to. I said, I'm retired. I don't have a job. I don't have a platform. I'm out here for the holidays. I said, I don't even have a box of stationery to write a letter. And he said, this is urgent, and you must do something. And I said, okay, you just call me back. He says, I'll call you back in 5 minutes. He calls back in 5 minutes. He says, have you thought of anything? And I said, no. He says, I'll give you 5 more minutes. Calls back 5 minutes. I said, Richard, I just can't think of anything in the world. And he said, I'll give you 10 minutes, but that's it. And I said, okay. He calls back in 10 minutes, and I said, look, I set up a Twitter account a couple of weeks ago, but I don't know how to tweet. And he said, perfect. Do it immediately. And I said, what did you not understand? What I said, I don't know how to tweet. He said, get it done. So I hung up. I went down to my office there, and I had no idea. But the short story from there on was, got in touch with my tech son, millennial son. And like all millennials, you've got millennial children, or you know about millennial children. I said, John, I have to tweet something very important, very long, and I don't know how to do it. Dad, I don't have time for this.
Don't you know how important I am?
We've been telling you and Mom that you're Neanderthals. You got to learn how to do this. I said, son, if you don't tell me how to do this right now, I'll cut you out of the will. Of course, he groused about that, and then he said, the instructions are in your email. Do you know how to open your email? I opened up the email, and there were the official Twitter instructions on how to tweet a thread. I dutifully followed them, and I had written on my iPhone what I was going to say during the phone calls. So I transcribed them into Word document, which is all I knew how to do. Then I cut it into 180 characters each somehow. And then I transposed them into Twitter. And then I stopped and I read each word one last time and then pushed the button. I had no earthly idea what I was doing. I didn't think any person in the world would ever see it. 10 minutes later, Richard called and he said, your tweet is on the front page of the New York Times. I said, Richard, just leave me alone. I hung up, and instantly, phone call after phone call after phone call from the national media. And of all the friends, that I had, each one of them would say, Judge, what did you just do? And I would say, well, what do you mean? You know what I mean. And I said, I know what you mean. They said, why did you do that? And I said, if there was a reason, I'm not at liberty to tell you. Next day, January 6th, Vice President leaves the White House for the Capitol for the joint session, which is to begin at noon. He released his letter to the nation saying that he was not going to overturn the election as the president had told him he must. And he cited my tweet in his letter to the nation.
Yeah. So I do want to ask you, in addition to Elizabeth, who is obviously a force of nature and urged you to do this, what was it that, compelled you to put yourself out there? Because so many people have become, I would say, choosing their political tribe over truth and the rule of law. We've seen that again and again, being silent in the face of things that should be objectionable, or going along with the con and advancing their own career or just taking the easy way. What you did caused you to, I'm sure, end friendships, incur the wrath of people who were diehards in the Republican Party, and make yourself a target of threats and harassment. And I'm sure you knew that at the time that you put that tweet out there. So what was it that caused you to decide to put your own neck and stellar reputation as a very conservative judge on the line?
Well, the issues that you raise actually weren't even in my mind on January 5th. The only thing in my mind on January 5th was that I was being asked to intervene in this greatest moment in American history, and that I had no choice but to do so. What I've subsequently said about all of us in this room and all of us is that we decide what we will do when the moment arrives for all the months and years leading up to that moment, such that when that moment arrives in each of our lives, there's no decision to be made. We've made that decision years before. And I've specifically said that that's the hero. The hero has made the decision before the moment, and in the moment there is no decision to be made. He or she does it. That's what I believe about people, all of us, in our lives. Every one of us. once, twice, 3 times in our lives, our moment comes in our family, in our community, with our friends and others, when we must stand and affirm what we believe and what we do not believe. And almost every one of us as ordinary citizens do that. The problem is our public officials never do it. For them, it is never a choice between their country and their party and their personal political ambitions, when in fact, every day of the week for our elected officials, they are obligated to choose between their country and their party, and they never choose their country. So.
Well, I want to follow up on that. We have been talking in the past about the decision that Mike Pence had to make. He's an elected official who had to make this very difficult choice. And sometime on January 5th or 6th, he actually said he was not going to be the one to show up at that certification convening and certify the election. And it looked for a moment like maybe Chuck Grassley was going to step in and do that. And it appears that ultimately he made the right decision. Do you think that your front page tweet had anything to do with compelling him to ultimately make the right decision?
Well, first, as Barbara said, this was not known for 2 years. And about a year and a half ago, an ABC reporter came out with a book, and he had the handwritten notes from the Vice President of the United States of America, quote, or effectively quote, "I have determined not to preside over the joint session of Congress on January 6th. When I read that, we were in Chicago, in our house in Chicago. I walked upstairs to Elizabeth and I said, "Stop everything. I want to read you these words." And I read them. And I looked at her and I said, "Oh my God, America came within that much of a revolution." And we had never known that. The first questions that I got, and eventually the question from the January 6th committee in my deposition, was, did I know or have any reason to believe that the vice president was equivocating until the last minute? And I said, I had no reason to believe that at all. But of course, I didn't have any inside information whatsoever. But to this day, people ask me, and then the media maintain, that the tweet was done in order to ensure that the vice president did not yield to the president's demands that day. And like Barbara said, you would remember it, I'm sure. You know, right there in and around that time, Chuck Grassley, he issued a statement that it was not cryptic in its terms, but it was cryptic in its message. He said something to the effect, "I may be presiding over the joint session of Congress on January 6th." I mean, when I read that, I went, what the heck? What the heck, you know? But the vice president's handwritten notes to himself taking. It's the only responsibility of the Vice President of the United States that's in the Constitution of the United States. When this came out, of course, the Vice President had to address it. And this is what he said. I had determined that I would not preside. And my son, who's in the military, was home that next day or the next few days. And he said to me, Dad, I take the same oath to the Constitution that you do. How can you possibly not preside over the joint session to determine the presidency of the United States? Those are his words. So it was an accidental conversation with his son who convinced him that he must preside and do what's right for America, and he did.
Yeah, so January 6th happens, and we see this chaos at the Capitol. We see this delay in the certification. Ultimately, they come back and certify. And then, some months later, Congress begins to investigate what happened on that day, and you are called to appear as a witness. You know, once again, you probably had an opportunity to say no thanks, and you again said, I'll do this, and you had to know this is going to be must-see TV. Your image will be all over America, and to the extent people didn't know who you were before, they will certainly know about you now when you recount under oath all of these things that have transpired. What caused you to agree to testify before Congress?
Well, first and most importantly, it was the greatest honor of my life, and it will always be. The first question I got was from an ABC reporter, and I said off the record, I said, yes, I have been asked to testify. And he said, may I please tell the world that? And I said, no, I'm not at liberty to give you that license, but you can tell the world this, that I said that that I would be honored to testify before the Congress of the United States of America. And he published it that day. So, leading up to that day, I spent about 3 months in isolation at our home in South Carolina. And I woke up every morning at 4:30. I read every single word relevant to January 6th and the Constitution of the United States from the time of its founding in the first 3 hours of the day. And then I took calls from the national media, the balance of the working day, all off record, all explaining to the media what had happened to America on January 6, 2021, and what were the constitutional and political implications of that for the United States of America, all off the record, because I was learning it myself. And every day I would write a few notes. When I write notes, it's the exact words that I intend to say in the future. So about 3 or 4 days before my testimony, I turned to the task of writing my prepared testimony, and I had every single word down to the comma and the punctuation marks that I was going to speak to the Congress of the United States. I just had to arrange them and organize them, and that was not much of an undertaking, except for the gravity of what I knew I was going to say to the country that day. But I did it, and it was ready. Now a fun story. I was staying at the Hay Adams the night before my testimony, and in a sad story that I'm not going to repeat tonight, Elizabeth would not come to the testimony because she was scared for my life and our family. She called me from the airport about 6 or 7 o'clock and said, "I'm here. Where do I come?" And I said, "Come to the Hay Adams Hotel." A little bit later, before she got in there, I got a call from the committee. And the committee said, "Judge?" I said, "Yes." "We've been told that you intend to deliver what you consider to be historic testimony tomorrow in the Congress of the United States. Is that true?" I said, "Yes, it is." And very nicely and politely, they began saying, "You just can't understand what tomorrow is going to be." And I said, I understand what tomorrow is going to be." And they said, "We just can't. We can't. You cannot appear tomorrow morning without the Congress knowing what you're going to say." And I said, "I'm sorry. I will be there, but I will not share my testimony with you in advance." And then a doubly fun story. One of them said,
What a hoot.
One of them said, "Your Honor, do you understand that if you were required to give us your testimony 24 hours in advance, and you didn't. And as a result, your testimony will not be part of the record of the Congress of the United States." Now, I know I look 25, but I'm actually 70, and I spent 50 of my years in Washington, D.C., and I'm a lot older than those people. And I said to him, "I could care less whether my testimony is going to be part of the record, but I assure you it will be." And they said, "Well, okay." And they said, "Well, what do you intend to do?" And I said, "CNN has had my testimony for 2 days. They will release it at 8 o'clock in the morning. You can get a copy from CNN." And that's the way it happened.
Well, it was riveting. I remember watching it, and to me, it was extremely persuasive. In part because you are, a legal scholar. You explained it in a way that made sense. But in our hyper-partisan times, it is really a shame. But we have become a society where people want to know this was a Trump appointee or an Obama appointee or a Biden appointee, because it seems like we want to categorize people by partisanship according to the president who appointed them. And so it was so powerful that you gave this testimony as a renowned conservative leading voice in the judiciary that was contrary to the interests of the Republican Party. And I think that was what made it so credible. is that there was, clearly no ulterior motive to it. I want to advance now to some continuing arguments you have made that also seem to go against the grain that we have come to expect people in our highly partisan times. And one was, you wrote a very interesting article along with a more progressive legal scholar, Larry Tribe, about the 14th Amendment and why the insurrection clause should have precluded Donald Trump from being on the ballot, including a decision that came out of Colorado. Colorado Supreme Court ruled that Donald Trump should not be on the ballot. Supreme Court overturned that decision, and you were a leading critic of that decision. What were your thoughts about that decision?
My clerks used to say that clarity is not the judge's problem, and that their job was to try to obfuscate my clarity. There's a kernel of truth to that. The Constitution of the United States of America forbids Donald Trump from ever holding the office of the President of the United States again. There's no question whatsoever. And I said after the Supreme Court's abominable decision in that case, as I later said in its immunity case, that the Supreme Court had betrayed the Constitution and America. Now, let me explain in brief. There was not one piece of legal evidence, not one authority, not one case law, not one statement in the law for the past 250 years that did not confirm that a person who, having previously taken an oath to support the Constitution of the United States and thereafter engages in an insurrection not against the United States, but an insurrection against the Constitution of the United States, shall never hold high office again. That is from the mouths of our founding fathers and the framers of our Constitution, and in particular, Section 3 of the 14th Amendment to the Constitution. What do we know that the Supreme Court did? Well, first off, I was on the line with one of our television networks moment to moment during the argument. Repeatedly during that argument, I said to the national television network staff and anchors, I don't even know what that question by the justice means. And the law is categorically against that question. And of course, the other thing I said to him at the end of the 3 hours argument, the Supreme Court of the United States didn't ask one single question about the issue in the case. Not one. The court never was going to decide that case. And of course, it didn't. In a per curiam, almost unpublished opinion that was, a first-year law student could have written easy better. They said, well, there's just nothing to suggest that the Constitution meant for the states to decide this issue. The express words of the Section 3 were the state could decide it. They were never going to decide it, and they didn't. Brings us to the immunity decision. My whole life I've been concerned and written and thought about presidential power. The first dream job I had was to head the Office of Legal Counsel, whose job it is to protect and preserve executive power as against the coordinate branches, power of the coordinate branches. Never before in almost 250 years since the founding of the nation had one single person, let alone a constitutional scholar, let alone a Supreme Court, let alone a Supreme Court justice, even suggested that the President of the United States would have immunity from prosecution for crimes committed against the United States of America. Donald Trump walked into the Supreme Court of the United States and said, I must have absolute immunity from every single crime that I might commit while President of the United States of America, if I am to be able to do my job. Preposterous. And our Supreme Court bought every argument, hook, line, and sinker. The day after that decision came down, the day of, I said it was the most abominable decision ever written by a Supreme Court of the United States, and I compared it to Dred Scott, Plessy against Ferguson, and the Japanese internment case. And the next day, and the next day, and the next day, and the next day following, virtually every constitutional scholar or thinking lawyer, for that matter, compared it to the same cases. Brings us to what Barbara's going to ask next, I'm sure. We judges answer questions. We don't ask questions. President Biden, 3 prongs or pillars of his proposal to reform the Supreme Court. The first, he proposed a constitutional amendment, in my words, to repudiate the Supreme Court's immunity decision in Trump versus United States. Second, he proposed legislation that would impose upon an unwilling Supreme Court of the United States simple ethical standards. Months before, I'd been called by the Senate Judiciary Committee and asked would I testify on that subject. And I said, I would be glad to. And I ended up submitting written testimony, and I explained that the Supreme Court of the United States should want to be bound by the highest ethical standards such that their conduct off the bench is beyond reproach, beyond all reproach. And then I explained it using the words of the founding fathers. And I said, the Supreme Court doesn't have the sword or the purse. It only has its judgments. And it relies upon the American people to respect those judgments for its power. Without the respect of the American people, the Supreme Court, in other words, is powerless. And then I went on to say, the extrajudicial conduct of the Supreme Court justices, collectively and individually, is critical to the respect that the American people hold for the institution and therefore for the court's judgments, citing chapter and verse from the founding fathers, the framers of our Constitution. And of course, immediately, the Supreme Court again said, no, we will not be bound by ethical standards. And belatedly, to say the least, it passed some kind of ethical standards, but of course, there's no enforcement mechanism for those. That's what President Biden proposed in that. The third pillar of his proposal was one that has long been of interest in mine, and that is essentially term limits for Supreme Court justices. What I told Barbara before we walked in here, I said, look, for my entire life, professional life, I've said that all federal judges, including especially the Supreme Court of the United States, should have 15-year terms. And that's my view. But I didn't want to speak to those other two issues on the day that President Biden released his, because I wanted to laser focus on the most abominable decision ever decided by the Supreme Court of the United States, giving the President of the United States and giving Donald Trump absolute immunity against any crime that he could commit, any crime that he did commit on January 6th, and any crime that he will commit if he's elected president in November of 2024. I said, and I don't say nothing unless I am absolutely certain of it. And I said that day that decision came down, I said, no longer can it be said in America that no man is above the law, because today the Supreme Court of the United States of America held that the President of the United States is above the law. If there's ever a reason to amend our Constitution, that's it.
Well, Judge, it's been so insightful hearing your perspective on these issues that we've sort of watched from afar. We're out of time for our conversation, but we do want to open it up for the next 15 minutes for your questions. We have people traveling with microphones to call upon you. So if you have a question, I can't see that well because of the bright lights, but I think our microphone assistants can. And so if you would be kind enough, just raise your hand and they will hand a microphone to someone. So I see a gentleman here with a microphone. Go ahead.
Hi, Eric Wanger. How are you? This is a question about, pardon my ignorance, but the crime of sedition may be the most severe, serious crime there is in our legal system. You could even imagine, using the Constitution for the death penalty in certain circumstances, if you really. But please remind me, what are the elements of the crime of sedition, and in an evidentiary basis, obviously there was a lot of seditious acts that day. A lot of people did commit sedition, but what is the evidence that Donald Trump himself, the man, committed the crime of sedition?
First off, it's not possible for any well-intentioned, conscientious American citizen to ask an ignorant question. Okay? Thank you for the question. This is a constitutional question only at this point. And as I said, the Constitution disqualifies a person who has previously taken the oath to support the Constitution from engaging in or aiding and abetting an insurrection, not sedition per se, an insurrection against not the United States government, but the Constitution of the United States. The insurrection against the Constitution that Donald Trump committed was in his effort to overturn the 2020 presidential election. He had, not only did he have no power at all to attempt to do it, it was and is to this day one of the gravest crimes against the United States of America that an incumbent president of the United States could ever commit.
How about another hand? Yes, I see one back there. Thank you.
I know, first, I say this mainly to servicemen that I see in the airport, but thank you for your service. You're an amazing human being. And I wanted to ask you a question that is not in your area of expertise per se, but is about your experience. Because most of us know that there is an election coming up, and most of us are concerned that if the election goes the way that a lot of people here hope it will go, that all hell is going to break loose in our country. And I wanted to know, not based on your judicial expertise, but based on your common sense and decency, what you think might or will happen if Kamala Harris wins the election.
Well, I have spoken a lot, even recently, on that very question, sir. But first, I told the Congress of the United States 2 years ago that Donald Trump and his allies and supporters are preparing, in plain view of the American people today, to overturn the 2024 election in the same way that they attempted to overturn the 2020 presidential election but failed. I said that 2 years ago to the American people. I've recently said, in response to the many articles that are being written today, that in fact, the former president, the Republican Party, and their allies have already prepared themselves to overturn the 2024 election if, in their view, it's necessary. And of course, we know what that means. That means if he loses. And this is no secret. Those are the words of the former President of the United States of America and the nominee for the presidency of the Republican Party in 2024. It is, again, breathtaking that these are the words and the actions of a president of the United States of America and one of the two political parties in America. The two political parties are the political guardians of our democracy. In his utterly inexplicable obsession with denying January 6th and glorifying January 6th for the past 3.5 years, the former president has corrupted American democracy, such that, in my view, there is only one candidate for the presidency and one political party in America that today can claim the mantle of protector and defender of America's democracy, the Constitution, and the rule of law.
Yes, over there.
Independent of the political issues in Congress, from a legal standpoint, do you think there are grounds for impeachment of Supreme Court justices?
Well, you're obviously, you asked the specific question, but a Supreme Court justice can be impeached, okay, according to the Constitution. Would that ever happen today? No. Because impeachment, of course, is by constitutional design a political process, not a legal process. And of course, we're living in one of, if not the single most polarized nation ever in our 250 years history. So, for instance, you couldn't get 50 votes to impeach anybody, let alone the 2/3 you'd eventually have to have. Now, I'm a judge, so I feel guilty when I'm not answering the question. So at least I'm going to admit that I'm not answering your specific question. The gentleman asks, are there grounds for? In my view today, there are not grounds for an impeachment. And of course, there never would be an impeachment anyway. Thank you for the question.
We probably have time for one more question, maybe from this side of the room.
Let them ask all the questions they want.
Sure, go ahead.
Thank you. Judge, given your reading of Section 3 of the 14th Amendment and how you view it, I'm curious, when it goes back to the states to decide if a particular person has violated the insurrection prohibitions, what due process rights does that person have? Does he get a jury trial? What's the standard of proof? Is it a unanimous jury?
Yeah, good question. First off, what we all need to understand is that the Supreme Court of the United States said this will never be a question for the states. I mean, this was, I don't even know what is the gravest misinterpretation of the Constitution, but this is right up there with it. And it was the Chief Justice of the United States who said it in argument, and the whole world, you could have blown him away with a feather, right? And he said this, he said, well, this is the 14th Amendment. Why would you, counsel, think that the drafters of Section 3 were giving power to the states? The 14th Amendment, of course, is circumscribing the power of the states, forcing them to recognize the equal protection and due process rights of the state citizens. Why is that so astonishing? Because that is the very opposite thing that the framers of Section 3 were doing in Section 3. And so, first off, the Supreme Court, it said, I mean, you can even believe it, it said, actually, we can't decide this question. Well, and so who could possibly decide this constitutional question, which they and they alone are obligated to decide? Well, we don't really know the answers to these intractable constitutional questions. So we're going to tell the Congress of the United States it's their job to figure this out. And that's what they did. The states will never have a role at all until and unless the Congress of the United States legislates to enforce Section 3. It will never in this world happen, because that's politics. And you can take to the bank it ain't going to happen anytime soon. Why? Because if the Congress were to legislate, Donald Trump would be prosecuted for his crimes committed on January 6, 2021. But finally, we judges, we try to remember the questions, even compound questions. Rarely do we succeed, but I happen to remember the last part of your question. As a matter of law, and in this instance, constitutional law, a person who is alleged to have engaged in an insurrection has no due process rights whatsoever. And no one has even argued that, except, of course, Donald Trump. So there are no due process rights. Why? Because it's not a penalty against the person. This is a constitutional policy that that person will, in the future, be disqualified. There's not even an argument that that person is entitled to due process rights. Now, because we're America, that person would be given more than due process rights, as the Colorado Supreme Court insisted, but which the former president did not avail himself of course. So it would never be an issue anyway. Next question.
Well, Judge, I'm afraid we're out of time, but he would go on forever, but you are a national treasure, and so we need to keep you close.